Well, hello, everybody. Yes, it's another Saturday at 3 p.m., and we're going to do another Zoom landlord tenant talk radio. I see we have a bunch of participants already in our room ready to be asking questions. I do want to talk a little bit today before we start about a topic I get at the office all the time, and that is, when can you serve a notice to pay rent or quit? What are the rules with regard to that? And then when you do serve a 3-day notice to pay rent or quit, when does that notice expire? Most people would think that 3 days, what's the problem? But of course, these politicians, these legislative people put all kinds of roadblocks and make things very difficult for lay people and landlords, income property owners to follow through. So I do want to share my screen here. And let's see here. Okay, so what I got is I got a calendar. So let's talk about when you can serve a 3-day notice. So a 3-day notice is allowed to be served the day after rent is owed. So in my example here, if rent was owed on the 1st of each month, in this case, rent would be owed on Friday, the 1st of March, which means you can serve a notice on a Saturday. Nothing prevents you from doing that. Again, rent is due the day that it's due and delinquent the following day. Now, of course, there have to be some exceptions. So let's take an exception where, in this particular example, rent was due on the 2nd of the month, on a Saturday. Well, if that's the case, then the tenant would not have to pay rent until the following Monday, the 4th, which means it would be delinquent the following day. So that means the first day, if rent was payable on the 2nd in the month of March, and since you can't have something due on a Saturday, Sunday, or legal holiday, the tenant would have until the 4th of March to pay, which means you couldn't serve the 3-day notice until the 5th. Now, I always give this example, and that is where in this particular situation, rent is payable, and it could be payable on any day, the 1st, the 15th, but in this particular example, I'm going to say rent is payable on the 24th of the month. Nothing wrong with that. And just for the fun of it, I'm going to pick a particular month, and I'm going to pick, ladies and gentlemen, the 24th of December. I'm going to pick the 24th of December, ladies and gentlemen. And let's pretend the 24th of December happens to be a Thursday. So I ask you, ladies and gentlemen, if rent is payable on the 24th of December, do you have the legal right to go over there on Christmas Day, knock on the door? As they open the door, you see the kids opening up the presents underneath the tree, and serve those people with a 3-day notice? Do you have the legal right to do that? And the answer is yes, you do. However, you'd be crazy to do so. So, but at least I'm trying to demonstrate what the issue is with regard to when you can serve a 3-day notice. Now, the next example would be when a 3-day notice expires. When you are counting the 3 days, it cannot be Saturdays, Sundays, or legal holidays. So if, for example, I served a notice on the 8th of March for rent due that was on the 1st, I couldn't count Saturday the 9th, okay? I couldn't count Saturday the 9th as a day because that's a Saturday, Sunday, or legal holiday. I couldn't count the 10th, which means the first day that you'd count, day 1, would be the 11th, the 12th would be the 2nd day, and the 13th would be the 3rd day. So the tenant would have till Wednesday, March 13th to pay the full amount of rent. If you're asking me when should you serve a notice if you really don't want the tenant to pay, I'd probably serve it on a Sunday, which is perfectly legal. You can serve a notice on any day once rent is delinquent, just like my example with with Christmas Day. But if you serve it on Sunday, they'll only have until Wednesday to pay the rent. And if you think about it, if you serve it on Friday the 1st, Saturday the 2nd, or Sunday the 3rd, they're going to have the same amount of time to pay the rent. So you might as well serve it on Sunday, ladies and gentlemen, if what you're attempting to do is to hope that the tenant doesn't pay the rent. Anyway, I'm going to stop sharing right now. And that was my little sermon for this Saturday. So always keep that in mind when you're serving 3-day notices, when you can serve a 3-day notice to pay the rent, and lastly, when that notice expires. Let's move it open now to our participants to ask some questions. Remember, this is for informational purposes only. It's not a substitute for legal advice. If you do want to ask a question, please electronically raise your hand, and I'll be happy to answer that. Also, if you have a particular specific case with my firm, please do not ask me questions on that. I wouldn't be able to look it up anyway. Please save those questions for calling us at the office. We just want you to do here just general legal questions. And with that, I'm going to open this up to Iris. Iris, I'm going to ask you to unmute yourself. There you go.
Hi, Dennis, and thank you for the sermon and for all the great information you give us all. My question is regarding an application of intent to evict for landlord or family occupancy. I filed that with the city, and they told me now I have to give them a 60-day notice to vacate. Now, aside from having the hardest time finding anyone to prepare this, I started looking for samples online, and I found what is a 60-day notice to terminate tenancy based on no fault, just cause. Is there a difference between a 60-day notice to vacate and a 60-day notice to terminate tenancy?
Yes, there is. For a family member or an owner move-in, there's specific language that has to go into that notice. And in addition to the common language that must go into a 60-day notice, dealing with issues, dealing with, for example, abandoned personal property, which has to be there. You also have to inform the tenant that which family member is moving in. You have to tell the tenant about their relocation. So it's a totally different form. And generally, there's not these online. Our firm does prepare these for our clients to make sure that they're prepared correctly and served correctly. Don't forget, when you serve that 60-day notice, and I presume we are talking about the city of Los Angeles, you also have to do that eviction cover sheet, and that has to be sent in to the city with a copy of your 60-day notice.
Well, they assigned someone to handle the case. She said to just give it to her directly.
We're not arguing that you can't give the 60-day notice directly to the tenant. That's one method of doing it, probably the best method. I'm talking about that you also have to send a copy of that 60-day notice with their new eviction cover sheet form into the Los Angeles Housing Department.
Okay. Now, one thing, I did contact your office and I did submit all the paperwork for them to do it, and I still have not heard back from them. Well, obviously, because I'm sure you guys are really busy.
Well,
but I'm trying.
As I've told everybody in the past, if you want to, they should get to it. Depends how many come coming in. But if you want to reach me on Monday morning, just hit my extension, which is 1001. You'll get me personally immediately, but that extension can only be used between the hours of 7 to 8 a.m. only. Do not use my extension otherwise, but I do leave kind of like an escape valve for clients to get to me directly. So call me Monday and between 7 to 8 a.m., hit my extension 1001 and you'll get to me. Anyway, thank you very much, Iris. We are going to move on to Frank. Frank, come on down by unmuting yourself, young sir.
Thank you, Dennis. 2 questions. Right now, given I'm an RSO fourplex, LA City. how long are you seeing cases take? And what are the not nuances? What are the items these tenant advocate lawyers are throwing to try to make something stick to default the case?
Well, of course, you know, the politicians, the city of Los Angeles, among other municipalities, have thrown in so many roadblocks, so many little tricks that you have to follow. Otherwise, your case will be thrown out of court. It's just the nature of the beast. And these tenants attorneys are adept at not being great trial attorneys, but what they are great at is finding these procedural issues that you have to go through. These cases are taking about 2.5 to 3 months currently. The biggest delay on these cases is the sheriff's office is taking about 1.5 to 2 months to do a lockout. In fact, I saw a lockout that came in today for LA County. This was in the Compton area, where we finally got a lockout date. I kid you not. And the lockout date was for May, ladies and gentlemen. So we're getting a big delay from the sheriff's office, but the cases are moving. But again, the defense attorneys, they're looking for these procedural mistakes that it's really easy for a landlord to make. Also, they're requesting jury trials in some cases. So, but again, you know, our firm is pretty experienced on how to handle that.
Thank you.
All right. Thank you very much, Frank. We are going to move on to Julia Jordan. Julia Jordan, I'm going to ask you to unmute yourself.
Hi,
Thank
Darren.
you.
Thank
Hey,
you.
how are you?
I'm good. I'm good. How are you?
I am great.
Great. Okay. So my property, I have a apartment building in Inglewood.
Yes.
And my question is, I rented to 2 roommates. One roommate has left. So the remaining roommate is looking for a replacement.
Mm-hmm.
So my question is, when she finds a replacement, and let's say we approve the replacement and all, I'm thinking the best thing to do is to sign a new lease. Am I within my rights to do that?
Yes, you can ask the tenant saying, look, as part of my permission to allow a new tenant to come in, I want you guys to sign a new lease. Or you can just sign an addendum to the lease that this is now a new applicant that is now qualified as a tenant. So either way, your tenant should be willing to do that, because quite frankly, if they're not willing to do that, you can say, well, I'm not approving anybody else to come in.
Okay, so I can refuse to let anyone else in if we don't sign a new lease,
I
because
think that's very reasonable.
yeah, and to your point earlier, because I did have a case where same situation, and because Inglewood does not recognize a tenant that has been there a year or less with any rights, and you can just give them a 30-day notice. So that's why I wanted to do the new lease.
Right, but I don't think that would help, because even if there's a new lease, they've still been in the unit more than 1 year. So I don't think that's going to help you in that situation.
Right, the existing tenant has, but the new one hasn't.
Correct.
And
But
so,
if the old tenant moved out and it's been less than a year, then I agree with you.
okay, all right, thank you.
Thank you. And before we move on to Christina, I wanted to tell everybody that the song of the day was from Loggins and Messina, and it was Danny's song. I always loved that song as a teenager growing up, which shows you how old we are, guys. Every song that I like is like 50, 60 years old. I used to laugh at my parents when they were into, Frank Sinatra and Dean Martin, but now look at us, we're all the same. Anyway, let's move on to Christina. Christina, I'm going to ask you to unmute yourself.
Okay, can you hear me?
Hello. I can.
Okay, great. I have a question about the 3-day notice. I have a City of LA RSO, a 2-bedroom that rents for $2,002. One of the roommates has moved out, and the remaining tenant only paid $1,001. I was watching your video for the 3-day notice service, and I understand I can't serve a 3-day notice for that 1,001 because it falls below the fair market threshold of $2,222. So my question is, next month, can I reject a partial payment of the rent?
Absolutely. You can tell the tenant, I'm not accepting the rent unless I get the full amount of rent. And then you're going to serve a 3-day notice, which will encompass all of the rent for the month of April and a half month's rent. That'll definitely be above the threshold. How many bedrooms again?
2.
So I'm not looking at a chart, but I think it's around 2,500, something to that effect.
It's 2,222 is the threshold.
I think that's an old one, my love.
Oh,
well,
I should still
let
be
me pull that up if I can real quick. Maybe not. Here, let's see if I can do this. Let's see here very quickly if I can. Now I got it. Let's see if I can do it. Okay, so the fair market value, this includes areas of LA County. Let's share the screen. Let's get fancy here. Where's my share button? There we go. And there we go. And share. Okay, so what we can see now is that this is the current one. For a 2-bedroom, you can't serve a 3-day notice unless the rent exceeds $2,544. So you're not going to take a partial payment. A 1-bedroom, as we see, is 2006. By the way, ladies and gentlemen, if you're ever thinking of renting out a unit in Los Angeles City or unincorporated areas of LA County, you'd have to be absolutely crazy to rent a 1-bedroom for $2,000, because now you're going to be below the threshold. So you definitely want to, in this situation, get more rent, get $2,400, because no other landlord's going to be renting out a 1-bedroom based on this crazy threshold that the city of Los Angeles and the county supervisors has instituted.
And one last question is, so what is my recourse to get that 1,000 that they, I guess they have to pay it
Yeah,
in the following
both
month.
tenants are individually and severably liable for the full amount of rent, including the tenant who left. He's still on the hook until the premises are vacated. But for the tenant who's in possession, do not accept a partial payment.
Okay.
Either they're going to pay you everything that's owed on, like today, they'd have to pay you half month's rent. But next month on April 2nd, serve a 3-day notice for basically 1.5 months rent. That'll be above the threshold, which is $2,544.
Okay, and I can't get them to sign the roommate addendum releasing that other, the vacating roommate.
You could, but why do you want them to? Why not
Right.
have more people responsible for your rent?
Yes. Okay, thank you.
All right, you take care. We are going to move to M. Brozar. M. Brozar, please. I'm going to ask you to unmute yourself. There you go.
Hey, Dennis, how are you? Thank you once again. I was in your podcast last week as well. Going back, I'm going to be moving into a house. I'm getting the tenant to be moving out. I got to give them a 60-day notice. But my question is, actually, I got 2 of them. Do I need to give them the notice, 60-day notice to terminate, or the 60 days notice to vacate?
Oh, they're both basically the same thing. You have to have the right language. A notice to quit, a notice to vacate, a notice to get off my premises. They're all the same thing as long as they have the magic words in it.
Also, do I need to put some type of code on this notice?
No code is necessary, but there is certainly necessary language that needs to
Right.
go into this. Is this in the city of Los Angeles?
Yes, sir.
Yeah,
Everything
there's
is LA.
definite language, as I told one of the first participants, there's definite language that needs to go into it. And if you don't have the right language, you're going to get thrown out. So
Yep. And the other question I have is, what's your feeling on the what do they call it, keys for cash or cash for keys? Do we need to, if it comes to some type of terms, is there a special form that I need to have that that I need to, I guess, record with the city?
in the
Or
city
no,
of
I guess not, huh?
you want to do a cash for keys, or we call it a voluntary vacate agreement. You want to do that as a last resort, but as an important resort, if you have no other way of getting a tenant out, and for pay purposes of that the rent is low and you want to increase the rent, then that's a wonderful vehicle. That you have to have special language in there. It's where you're going to have a hold harmless and a release of liability. You have to have certain language in that, which for the city of Los Angeles says, well, quote, a cooling off period. That language has to be in the notice. So this is nothing that, quote, a lay person can generally create on their own. So if you're ever thinking of doing some voluntary vacate agreement, then you definitely want to enlist the services of an attorney.
Oh, okay, I guess I'll call you.
Thank you.
you.
Okay, let's move over to Greg. Greg, I'm going to ask you to unmute yourself and say hello.
Hello, how are you, Dennis? Thanks
I
for
am-
doing this.
No problem.
I really appreciate it. I had a question. So we have a maintenance guy we're hiring, and he wants to move into one of our units. Do you recommend that they get, I have a contract that was pre-state like wide rent control that we used to use. Do those people, should they have some sort of a contract that we sign and do you provide them, or do you know where we could get them? That's something that's a little newer, or do you
Okay,
think
so
it would
this
make a
is-
difference?
This is a maintenance man you're talking about?
Yeah, maintenance, and he might do some he might be an assistant manager at a building, so.
Is he, okay, is he going to pay rent?
He's gonna have he's gonna get salary, so he's gonna get a deduction in rent.
Okay, I would definitely do a managerial agreement in that situation. But our firm doesn't deal with that. You're gonna need to enlist the services of a labor attorney. You have no idea how easy it is for employers to get sued, even in this situation, based on the hourly rate and minimum wage and how the agreement has to be structured. So if he's working for you, I would definitely enlist the services of a labor attorney. I know Gary Ganshow, who's part of the Apartment Owners Association, would be a good person to use. And by the way, while we're on the subject, let's not forget the fact that on March 20th of this month, at the Los Angeles Convention Center, the Apartment Owners Association will be kicking off their $1 million trade show. It's an all-day event. You'll get to hear many people doing seminars on a bunch of topics. I think Gary is going to be there as well. Also, you'll get to see people, vendors who are showing their supplies and services, insurance and plumbers and ways to renovate your units, earthquake. And you'll just get so much additional support in terms of running your buildings more efficiently, and being able to really learn a lot from this seminar that's coming up. And of course, Dennis Block will be doing his seminar at 1:15. That's in the main seminar room. I'll have a booth there as well. So all day, it's right by the main seminar room, which is Seminar A. And so you guys can come up to me all day long, and instead of hitting me in this Zoom meeting, you'll actually be able to get to see me and another one of my associates. And I'll also have our collection expert, my son Brandon Block, who does all the collections in our office. He'll be there as well. So
One quick question. Did they sign a lease and the security deposit as well then if they move in?
yes, they should sign a lease too, but you should have that employment agreement.
What's how do you spell that guy's name, the attorney you were mentioning?
I'm going to
Ganshow.
butcher it. I don't think, if you go to the AOA website in their magazine, Gantro, I think it's Ganchrow, Gary.
Okay, thank you.
Okay, let's move along to George. George, I'm going to ask you to unmute yourself.
Hello.
Hi there.
Hi, Dennis. Let's see. I've been managing a property for a long time. I have a multi-tenant commercial building in downtown Los Angeles, and the ground floor has retail stores. One of my tenants with one of the retail stores has fallen behind in his rent, and in February he had only paid me $500 of his $3,000 per month rent. I personally walk the property twice a week. And on one of those days, I met him on my walk around, met him outside of his store and told him that he owes me rent. We are not partners. I am not the bank, and that he needs to go find money, or if he cannot afford the place, please move out. He emailed me later in the day, told me that I humiliated him in public, and without getting into too much detail, included in the email, it sounded like he is intending to sue me for psychological damages.
Well, he's psychologically damaged by just saying what he said. Obviously, he's out of his mind.
Right.
First of
You
all,
know,
it's fair to humiliate people that don't pay the rent. Okay. And you merely walking up to him and asking him is certainly your right as a landlord and also as a citizen of the United States. So that guy's whacked. The first thing I would do is I'd serve him with a 3-day notice and proceed forward with an eviction on that, because this is a really bad egg.
Okay.
And he's just trying to bluff you into not taking legal action.
Okay. So his lease has terminated. It's on a month-to-month. Am I better off that saying that your lease has expired, you have 30 days to move out, or am I better off with a 3-day notice to evict him?
What I would do, since I think you've had enough with this person, I would do both notices at the same time. I'd serve you a 3-day notice to pay all the rent that you owe me. And by the way, even if you do pay all the rent that you owe me, here's a 30-day notice. I still expect you out in 30 days. In that situation, most tenants will not pay the rent and will be able to start the lawsuit after the 4th day.
Okay. And I shouldn't worry myself about the psychological intention of his suing me.
You know, people have to have a cause of action to be sued.
Okay.
So this is just total garbage.
Okay.
It's just designed to make you not want to move forward with your rights, and he's doing a good job.
Okay. And your company would be the best to handle this eviction, and
We handle residential and commercial evictions.
excellent. Thank you very much. I really appreciate
And
it.
thank you. Okay, let's move on to PK. PK, I'm going to ask you to unmute yourself. There you go.
Hello. Hi.
Hey there.
Thank you so much for doing this every week. We really appreciate it. So I have a rent control building in the city of Los Angeles, and we have a tenant who owed back rent from COVID that we were finally allowed to move forward with a 3-day pay or quit after them not paying in February. Took us a while to kind of get all that together, but we served them this last week. We anticipate a fight. So the question is that they also, the same tenant also has a kiln that they put on the property to bake ceramics. It's a very large kiln. And then they built a lean-to onto the building to enclose the kiln, all without our permission. This all happened during COVID, and our management company suggested at the time that we didn't do anything about it because COVID. And my question is now that COVID is more or less in the rearview mirror, what is the stronger position, or what is the more expedited way of going about getting them out? Is a 3-day pay or quit for the money that they owed just as just as good as going after them for a 3-day performer quit to get rid of the kiln? Should we pursue both at the same time? What is your suggestion there?
Thank you. First of all, your management company gave you improper advice. The fact that they made alterations to the premises, even during the darkest of COVID times, you could have immediately moved forward with that eviction. So that was just poor advice on the basis of the management company. I don't hold them at fault, but because there were so many laws going back and forth, who knew what to do? And the average person didn't think anybody could file any kind of evictions. During COVID, we filed tons of evictions. We couldn't do it for rent or certain items, but we certainly could have done it for alterations of the property. So what should you do now? Should you go on the non-payment of rent? Well, Just to let you know that, and I do have a cheat sheet here, any rent owed from March 2020 through September 2021, you had to serve a 15-day notice to pay rent or quit. If it was rent owed from October 2021 through the current time, today, then it would be a 3-day notice. So assuming you were talking about the latter period in time, I would serve both. I'd serve a 3-day notice to pay the rent, and I'd serve a 3-day notice to remove the alterations that you did. Serve them concurrently. And it's basically like having 2 bullets in your gun. And if I have a gun and I have 2 bullets in it, and I shoot the first one at somebody and I miss, and I shoot the second one and it hits him right in the head, he's dead. So it's always better to have more bullets in your gun, the way I look at this.
But there's one isn't more likely to go to court than the other or anything like that.
No, I mean, they'll go to court on anything. So
Okay.
on that basis.
Fair. Okay.
All right, you take care. We're going to move on to, let's move on to Diana D. I'm going to ask you to unmute yourself, please. There you go.
Hi, Dennis. How are you?
I am fine.
Good. Hey, Dennis, I have, it seems to be the theme of the day. I have a tenant that I've just found out, it's a complicated situation, that they've made some, well, that they were renting out the garage. They also were stealing electricity from Edison or DWP in LA. And so this is a non-RSO, city of LA. Anyhow, I really just feel like I want to get rid of them. They pay their rent on time. I have March's rent. I haven't cashed it yet. And
Well, let me ask some questions to
okay.
get to the chase here. You say
Okay.
it's in the city of Los Angeles. It's not under RSO. Is this an apartment or a house?
It's a house.
There's only one house on the lot?
Only one house.
When you say they're renting out the garage, are they renting out the garage for someone to store things in there, or they're renting out the garage for someone to live there?
They were renting out the garage for someone to live there. The person is not living there anymore. Because they got caught, you know, they had an illegal bathroom they built. They had, I mean, it's just a terrible.
We can certainly go on, again, notice to perform or quit for alterations to the property.
But does that mean they can stay then, or?
Well, they'll have 3 days to remove all the alterations. I doubt they'll do that.
Well, they've
ahead.
removed most of the alterations. There's one last thing, and it's just capping off some piping that they took out to the backyard for a washing machine. But I'm assuming where they had a bathroom, they must have, tapped into the sewer. I don't know how they would even.
Well, you have the right to ask them to put it back the way it was within 3 days, which they're probably not going to do. So on that basis, I think you do have a case for eviction. Other than the use of the garage, was there another issue that they were doing?
Well, stealing electricity. Well, okay, long story short is that they told me
Who
that
were they stealing electricity from?
the electric company.
Okay, well, then that's not your problem. If they're stealing,
no,
if
but
they're
I mean,
stealing it from one of your other tenants who are on the
Okay,
property, which you don't have any, then that's.
well,
Go
let
ahead.
me tell you what the problem is. So they emailed me that Edison or whoever it is turned off their electricity because the electrical panel blew. And so I got my contractor out there and I said, it's an older house, a really old house. So I said, go out there and as soon as you can, replace the electric panel because they were living off of a generator. And so then it comes to find out that it wasn't my electrical panel blowing. Edison turned off their electricity because they were stealing it in 2 different directions to light the bathroom shack and to light the garage that they were renting out.
Right, but again, this is between them and the electric company.
No, but it cost me $3,800 for a new electric panel. I mean, I'm really ticked off.
Well, then hold on.
Okay.
If they created a situation where now it costs you $3,800 for a new electrical panel, then that's a ground for eviction. We can make a demand for them to reimburse you based on the terms of your contract. There was no reason for you having to replace the panel except for their actions with the electrical company. So I think you have a great case for eviction.
Okay, I'll be calling you on Monday.
And I'll be there to listen. Thank you very much. Okay, let's move on to Harold Rhodes. Harold Rhodes, I'm going to ask you to unmute yourself.
Hello, can you hear me?
I can. How are you, sir?
Good, good, good. I just want to clarify something. Owner occupied single family residence, Woodland Hills. If I live at the property with a tenant, I can take over the property, or I'm not able to take over the property as far as owner move-in if I already am living there, but I want to take over the whole property.
The answer is the answer is yes. You can do an owner move-in because you don't want to live with anybody anymore. So that would be a ground to evict.
And the caveat, how long do I have to wait until I can sell the property if I wanted to sell the property after
You
I
can
have?
sell the property today with you and this other person there. Nothing prevents you. The issue is whether the purchaser is going to want to buy the property with this person in possession.
Yeah, that's what I'm saying is how long am I able to, once he's gone, I can sell it right away?
Well, of course.
Okay, I just didn't know, like.
Oh, I see what you're saying.
Yeah.
I see, because technically, if you wanted to occupy the property, you're supposed to be there for 2 years.
Right.
Yeah, I think you'd have to stay there for 2 years. My first impression on your issue. That's what.
Do they have a system in place where they monitor you?
You know, the other way to do it is you can just raise the rent to this person. I presume he's on a month to month.
Yeah.
So let's just raise the rent.
You can raise it more than once a year?
You can raise it to whatever you like, whenever you like. This is a single family home.
So every month I can raise the rent.
Yeah. I mean, you'd have to do a 90-day notice if you're going above 10% in any 1 year period.
Right. So I could make it 10,000 a month and then.
Well, I wouldn't go out of your mind, but I would certainly increase it because you don't want it to look like that you're just doing that to get rid of them. But I would certainly raise it, and I think that'll have the desired result.
Let's just say I raise it to 10,000. Do I have to give him the 10,000, or is it the very last month that he paid that I have to give him?
You're talking about economic displacement, where if the tenant chooses not to pay
Yes.
the increase, then he's entitled to rent. In this situation, it would only be 1 month's rent.
But is it 1 month's rent that he paid or the new?
Well, it wouldn't make a difference because you're just going to give him a credit. But it's the rent he was paying, not the one you've raised it to.
Okay, because I got some extremely bad advice from a loser attorney. I will never go anywhere except for you. I've done a number of transactions in the past. Anybody listening, don't play games. Just go straight to Dennis. He'll take care of it.
Oh,
Seriously.
you're very kind. You're not my brother, are you? No,
Yeah.
I'm just kidding. All right.
The debt collector.
All right, Harold, we're going to move on to Nancy. Nancy, I'm going to ask you to unmute yourself.
Got it. Hi.
Hey there.
Okay. So after a tenant has been taken to court for eviction and was approved and given a date to vacate, no monies were required to pay at that time. Can the landlord file a default money judgment after the fact? And is that even still legal? Because someone recently told me that law or whatever ended in 2022, which I cannot find that information anywhere that it ended.
Okay, let's get more specific on this. You say you went to court and you got a default judgment? Or you went to court and the two of you settled?
Well, it was settled in terms of them agreeing to leave in 45 days.
Okay, so this was what they call a stipulated judgment and you were
Yes.
at trial.
It was not a jury trial.
No, I didn't say that, but you were at
Okay.
the court for a trial and you guys entered into a stipulated judgment.
Yes.
I would bet that stipulated judgments would say that you waived the rent, period. So I'd have to take a look at what occurred, but normally, unless it said that the rent was reserved for further action, which I doubt it had the words reserved on it, you basically waived your rights to collect any rent and gave them 45 days to move off. That's a common type of a settlement. And you'd have to take a look at the stipulated judgment. There's an amount on that where it says rent owed, holdover damages, and I bet you they're all crossed out with zeros. Unless it says the word reserved, you basically gave up your rights to rent. And what you did was you just made an economic decision that the tenant would move in 45 days and get the hell off my property.
And that was because at the very first words out of the attorney, and this was before, this thing has been going on forever, and before you even came into the picture, which that's another story, but that was my very first question, was the money part, and that's who said, no, you can't do that anymore, because I said, no, we're talking about $1,000, and so I said,
Right.
we want to file.
Well, then you see, you have to understand, if that was put into the agreement, who says that the tenant would have signed it? You know, it takes two people to make an
100%.
agreement.
They might have,
So
yes.
he might have said, I'm still going to be responsible for all the rent. Well, forget it. I'm going to go to trial. And I bet you it was set for a jury trial, right?
100%. That's very well what could have been. I mean, but he didn't even try.
Right. But in most of these cases, the issue is whether you're going to be able to collect the rent. It's not like the tenant at the trial takes the money from his pocket and hands it to you. It doesn't work like that. You get a judgment. It's a piece of paper. Whether you collect on it or not is another story.
So it's not even worth the garnish and wages and bank, all of that.
Sometimes it is. I mean, we collect over 6 figures a month in debt based on our collection agency on judgments that we get from tenants. But in a lot of cases, the guy doesn't have 2 pennies to rub together. So, all right, Nancy, thank you very much. We are going to move on to David. David, I'm going to ask you to unmute yourself.
Yes, hi, Dennis. My question is, in a large show built before 1978, I'm confused. Are you able to terminate tenancy based on remodeling? And if not, what if you have a 2-story and you want to demolish everything and go up 4 stories? Can you please answer this question?
Sure. If your property is subject to RSO, the Rent Stabilization Ordinance, which is multifamily dwellings built prior to October 1st, 1978, you cannot evict a tenant for a substantial renovation. If your property is not under RSO, we call it under JCO, the Just Cause Ordinance, then you certainly can ask tenants to move based on the fact that you're going to do substantial renovation as defined by the city of Los Angeles. Now, if you're going to either demolish the premises or permanently take that unit off of rental housing use, whether you're under RSO or JCO, regardless, you always have the right to either demolish something or permanently take it off of rental housing use. So if you're going to reconfigure this building that has 2 units to make it 4, where those 2 original units are no longer going to be there, they're reconfigured, then yes, you could do that.
Thank you, Dennis.
All right. Okay, let's see here. I was talking to David. Let's lower your hand. And let's move on to Jim. Jim Polina. I'm going to ask you to unmute yourself.
All right.
Hey
Nice
there.
to talk to you, Dennis.
Hey, how are you?
This is a great service you're offering everybody. Fantastic. So I got 2 questions for you. One was based on something you mentioned in YouTube regarding entry. If entry is being blocked or denied by the tenant, should I give 2 notices at the same time? One, a 3-day notice to perform or quit, and at the same time, another notice to enter and then try to gain entrance by the 3rd day. Do I have that right?
First of all, what city are we talking about?
Sorry, I'm located in San Luis Obispo County.
Okay. I don't really know that area, whether they have
There's no rent control whatsoever.
Okay, well, there is rent control, but it's statewide rent control. And
1482.
one of the grounds for eviction under statewide rent control is failure to provide access. So there's 2 ways that you can do it. You can go like a couple of 3 times to try to go in serving access notices. And I put right on the access notice, if you do not allow entry, then this is going to be grounds for eviction. Then at that point, if after the third attempt, they don't let you in, then I would serve a 30 or a 60-day notice to vacate. That's one way to do it. The other way to do it would be to serve a notice to perform or quit stating that, hey, you haven't let me in for the last 2 times. So within the next 3 days, which is how we handle it, in the next 3 days, you need to contact me and let me know when I can come in within the next 7 days. If you don't contact me, I'm going to be there on the 4th day. And then I will, and if you don't let me in on the 4th day, I'm going to go straight to eviction. So that's another way. But I do want to ask you this. When you say she won't let you in, how does she prevent you from going in?
She bars the door from opening.
Okay, so she's inside and she has an inside lock. Is that correct?
I have a key to the lock and I can unlock it, but she has physically barricaded the door or somehow barred the door
Yeah,
from
maybe
opening.
there's another bolt on the inside. Yeah, so that's how I would handle it. And put right on
Okay.
those access notice that, hey, I am not going to let you, if you don't let me in, this is going to be grounds for eviction. Put it right on the notice so she can't claim some sympathy to the judge.
Okay. I do have a second question. Ideally, as a landlord, I don't want my tenants moving out during the holidays. How do you recommend handling that? A month to month, and you cannot move out on the holidays, or a lease that avoids the holidays as far as a turnover date?
Well, then you'd have to do a lease. I mean, anybody can move out. I mean, you don't run a prison. The issue is whether they're going to be responsible for that period
Right.
of time. And yeah,
Right.
you just do a lease that, you know, is going to end, let's pretend, in March 1st of 2024. So that
Right.
you missed every holiday.
So it's unreasonable to go month to month. Oh, by the way, also in the month to month lease, you cannot move out during these 2 months.
That's difficult to swallow.
Yeah,
Something.
I thought so. Okay.
All
Thanks,
right, Jim.
Dennis.
Good luck to you. All right, let's move on to, I see a phone number here ending 0497. If I'm going to ask you to unmute yourself. 607 is the beginning of the number. Oh, by the way, if you're on a phone, hit *6. *6 to unmute yourself if you're on a phone, to our number of 49607. *6. If not, I'm going to move on. You tried. *6 should unmute you. Nope, I guess not. Let's
How
move
is that,
on.
sir?
Oh, there you go. You got it.
Hi there.
Yes.
Hey, good afternoon. Big fan, Mr. Block. By the way, I know you don't want to talk about it, but I did see the sensationalist lawsuit on following your Twitter link. Hopefully that's going okay for you.
I appreciate
But,
that. Yeah,
at
we'll
any
have a
rate-
big ruling on March 18th. Keep your fingers crossed.
Just to continue the conversation with regard to collecting rent debt, I work for a property management company, and one thing that's been brought to my attention, which we haven't availed yet, is using a 1099-C for well-to-do tenants. I know it's probably worthless for tenants living paycheck to paycheck, but if you were to threaten a 1099-C, that becomes essentially a taxable event for the tenant by forgiving the rent debt. So now they're going to be liable for taxes, and I'm wondering if that might be a good bludgeon, if you will, to, for lack of a better term, extort them into paying COVID-related rent debt, which I know that you say that the chances are very small that they're going to pay it, but maybe by filing a 1099-C and creating a taxable event, then they would have a little bit more motivation to cough up that rent debt.
Well, okay, so for everybody out there, what the gentleman is talking about is that if you forgive a debt to somebody, that's considered income to that person. So you would, you know how you get these 1099 forms at the end of the year? Well, this is a 1099-C, which basically is dealing with forgiveness of debt, which means that now if I gave up $20,000, Mr. Tenant, that just means you just earned $20,000 and you're going to have to pay Uncle Sam that percentage. Of course, in the state of California, it'd probably be about 98%, right? With the crazy taxes we have here. So is that going to be incentive? Well, don't forget if you're going to forgive the debt, then the tenant can think to himself, well, look, I'm only paying 50% taxes or 40% taxes, so maybe it's better than having to pay the landlord 100% taxes. But I think it can be used as some sort of a threat to the tenant to assist them in at least paying you something on that. So I don't see that as a bad idea.
So it might be a bargaining chip to negotiate a settlement, in other words.
Right. But for any landlord who has no hopes of collecting and the tenant just ran away, get yourself out of, if you're not planning on collecting that debt, then please get yourself out that 1099-C and file it with the government so that all these people who escaped without paying rent at least will have to pay something.
And if that's to no avail, I understand you have some tentacles, and or you've mentioned your son handles debt collections. How do I'll just reach out to you, or is there another firm?
We do debt collection based on judgments. So if you have a judgment or if we have obtained the judgment in eviction cases, that's what we do. We're really good at locating assets, assuming assets exist. If the guy lives out on the street, trust me, we're not going to collect at all. But if the guy does have some wherewithal, works at a place, or has assets in a bank account, or even owns property, we have the ability to find it. Now, when a tenant gets evicted, for example, and we have a judgment against them, you know what? The chances of collecting probably are small in the first year, but it's not small in the years to come. We check it every year, and maybe 3, 4, 5 years down the line, we'll be collecting on a judgment because the guy got himself back on his feet, and then all of a sudden we push him back down. And with that, sir, I'm gonna move on. Appreciate you participating. I think I already talked to Joseph, I believe. Let's talk to Tanya Belmontes. I'm going to ask you to unmute yourself. Tanya, are you there? Last chance. Oh, there you go. Hi there.
Hi, Dennis.
Hey there.
Questions. So I have 2 properties, city of LA. I have spoke with you already. I think I talk to you every week too. In Los Angeles.
You don't live in Tarzana, do you?
I have what?
You don't live in Tarzana, do you?
No, I live in Rancho Cucamonga, but you
Okay.
have helped me. You have helped me already. I have spoke with you.
Okay.
I have a tenant. You know her very well. Her name is Maria.
Okay.
So yeah. So I've been actually calling your office. They haven't called me back, but we'll talk about that after. So I want to do to move into the property, but now they're talking about they're getting together to get an attorney. But I just found out from housing that they're protective if they apply for the rent, if they have
I think you're all over the board, Tanya. So let's clean it up a little bit. It's 2 things. Number 1, you want to move into this property, is that correct?
Yes.
Okay. So is this an apartment or a house?
There's 2 houses.
It's 2 houses on one. There's 2 houses on one lot. Do they both have the same? Stay with me, young lady. Do they both have the same amount of bedrooms?
Yes. No,
what,
one is a 3-bedroom and the other one's 2-bedroom.
Okay, and what city?
Los Angeles.
Okay, do you want to move into the 3-bedroom or do you want to move into the 2-bedroom?
My brother's gonna move to the 2-bedroom. I want to move to the 3-bedroom.
And is your brother also an owner of the property?
Yes.
Okay, so then you both can ask these tenants to move unless these tenants are over 62 and have lived there longer than 10 years. If that's the case, then they're exempt from being asked to move. But assuming they aren't been there 10 years and also are over 62, then we can move forward with an eviction. We have to go through a process with the city. It's an application process for each of those units. We have to pay relocation money to those units, depending on how long they've been there. It's if they're over 62 or have children or are handicapped, it's about $24,560 or $650. If not, it's around $12,000, but that's what you'd have to pay. But in both instances, since you're both owners, we can ask both of those tenants to move. But don't forget, when we do that, number one, you have to live there for at least, you have to live there for at least 2 years. And when you move out, you can't raise the rent on these units. It's whatever the tenant was paying plus whatever applicable increases that the city would allow.
Okay, but I went on Thursday to housing, and now they telling me that they're protected if they apply for the rent, because one of them
Yeah, no,
owes rent.
that's incorrect. You're getting bad information. They're protected if you're trying to evict them for non-payment of rent, where they have applied for housing assistance. It's called the ERAP. Let me pull it up here, which I have it to my right here. And it's only for non-payment of rent for the period of rent that was owed from January. Let's see where it is here. It's from October 2021 through January 2023. If there's an application pending for non-payment of rent, then you can't bring forth an eviction until May 31st. But this has nothing to do with you moving into to the property. So those are two separate concepts. So who's ever advising you from Section 8 is just wrong. All right.
No, it's not Section 8. It was for housing.
mean, from Los Angeles Housing Department, excuse me. All right, we're gonna move on. I'm gonna move on to Sonia. Sonia, I'm gonna ask you to unmute yourself.
Yes, Dennis.
Yes, hi.
Hi. Thank you for doing this. My question has to do with security deposits. So we have a tenant that moved out, and we had the initial security deposit, but then we had a separate key deposit. So my question is once they move out, they do have a month of unpaid rent. And so between that and the cleaning, if we exceed what he left for security, the regular security deposit, can we take it out of the key deposit, or is that just for the keys?
Okay, well, first of all, there is no such thing as a key deposit. All deposits that you take are considered a security deposit. And currently you can get up to 2 months rent, and soon come July, it's only going to be 1 month's rent. So it's all considered a security deposit. It's added up into one big lump, and then you are allowed to deduct for any rent owed, any unusual wear and tear, and any cleaning to the units.
Great, thank you.
You're very welcome. And let's move on to, I love this name. It is No Name. No Name, I'd like you to unmute yourself, if you'd be so kind. No Name, are you there? Well, it makes sense if you don't come there. No Name? Okay, we're going to move on to Victor. Victor, I'm going to ask you to unmute yourself.
Thank you, Mr. Block.
Hi.
Thank you. We have a tenant in a commercial storefront in the city of Los Angeles who moved out in March of 2023, owing about $17,000 in back rent. She signed a promissory note. She's in default of the promissory note. Can the owner proceed in small claims court in excess of the $12,000 limit?
If this is considered COVID rent, it is. What city?
Los Angeles.
Okay, so Los Angeles, if it was any rent owed prior to February of 2023, then you could sue unlimited.
Okay.
For commercial.
That's the answer. Thank you, sir. Perfect answer. Very concise. Adios.
I try to. Okay, we're almost at the end here. I'm going to go to Tim Furholt's iPad. I'm going to ask you to unmute yourself.
Hello.
Hey, you don't look like a Tim.
I know, that's my husband's name. It's his iPad. Our tenant, we went to, he's supposed to move out. We went to court. We agreed that he was to move out on the 10th, which is on Sunday. If he doesn't move out by that day, it's supposed to be unsealed. Okay, he does not look like he's moving out. He was evicted, and so if he doesn't move out by the 10th, what's going to happen? I mean, I know the sheriff is supposed to go out, but you said now it's supposed to take 20 days.
Okay, well, we don't talk about specific cases, but I can just let you know, regardless of what's agreed in court regarding when the tenant is supposed to move, we're still at the mercy of the sheriff's office as to when they're ultimately going to do an eviction. If the stipulated judgment was designed and written in so far as that the record is unsealed, if the tenant doesn't vacate timely, then we would have to file, or an attorney would have to file, depending on who did the stipulation, with the court, a statement or a declaration to have the record unsealed on the basis that the tenant did not vacate timely.
Okay. Also, so can I go and ask him to move out on the 11th and say, leave?
Absolutely. Say, hey, why are you still here? You signed a judgment that you were going to get out. But of course, we know that unfortunately the sheriff's office, regardless of what the court order is, the sheriff's office is not going forward. I thank you very much. And I'm going to take one more call, and the lucky one. We can do this next week, ladies and gentlemen. I'm going to take Mia Mathis. I'm going to ask you to unmute yourself. Hello, Mia. There you go.
Hello. Hi, Mr. Block. Quick question. If I I have a single family home in Los Angeles City, and if I give a rent increase, do I have to do a proof of service if I put the rent increase taped it on their door and I send it through regular mail?
No, you don't need a proof of service. You just need to serve it correctly. And you did serve it correctly. You do have to allow an additional 5 days for mailing if you didn't hand it to the tenant. But you don't need a proof of service. That would only be if something gets contested and he claims he never did it, then it would be your oath, your testimony in court, which would say what you did.
Okay, thank you.
Hey, thank you. And by the way, everybody, I appreciate everybody joining in on our beautiful Zoom meetings. I can't tell you, as much as you like this, I really like this myself. It's really fun for me to do this every week. I guess I can't get enough of answering clients' phone calls. Guys, you can always call us at the office, which is 1-800-77-EVICT. You don't need to be a client for us to answer your questions. Don't forget that beautiful trade show coming up. I'll remind you again next week, but it's March 20th at the Los Angeles Convention Center. You get to see me and a bunch of other people giving a very nice seminar that I'll be doing. I have a PowerPoint presentation that's going with it. So I'm going to sign off. Have a great weekend. Be safe. And thank you very much. And don't let tenants push you around. Thank you.